Hi guys, and welcome to my Diana Romanovska family law channel. I'm sitting here in my garden. Sorry for the light and the wind. However, I really wanted to film this video today on Sunday, not so sunny, in San Francisco. I practice family law in San Francisco, and I thought today I would like to talk about what a lot of people would like to know: when can I be finally single? They come to my office, they have been going through a lot of difficulties in their marriage, and my clients really want to get to know when to be single. And the answer to that is California has so-called cooling off period. What it means is once a party, the moving party, filed for divorce and arranged the other person to have served. I can do another video about service. There are different ways to serve. But let's say the other side was personally served. Then there is, from that point on, not from the date of filing, but from the date of service, the time starts to ticking 6 months and 1 day. And after 6 months and 1 day, a lot of clients, I'm surprised, assume that it's going to be automatic. It's not. There are two scenarios where it could be semi-easy. Is, let's say, in uncontested divorce, where both parties in agreement about everything, they file the package, they submit it, and everything is done super fast in 3 months, and they get court paperwork back in San Francisco maybe within 3 to 6 months from the court, depending on how packed the courthouse, the judge, and what time of the year it is, and they get it back. The date when both parties can be single, it will be 6 months and 1 day from service. So you could receive a package 2 months before you will be single. So you can use that form, and it's not very shiny, not very great looking form that shows that you're single. It's just a standard form, FL 180 judgment, that will say divorce, dissolution on, and then you will see the date. It's right on top. Then there is another scenario. For example, if the divorce is not so amicable and it's dragged out, let's say custody battle or property or whatever that could be, and then you still like to remarry, and it's already 2 years past and you really want to be single. So then for that purpose, you would file a so-called bifurcation status only. There is a little help in one form that I found really helpful. It's a form FL 347. You can Google it. Obviously, none of what I'm saying is constituting legal advice. It's just general information that you can look up. On that form, it says, and it's the law, 2 requirements to get status single. So you would have to file a motion. The form doesn't say that. I'll come to that in a second. You file a motion, request for order, you get a hearing date, and you can get the single status only most of the time if 2 requirements are met. Number 1, preliminary, the moving party, meaning the one who wants the single status only, served preliminary declaration of disclosures to the other side. It's called PDD, or there are 2 forms: income and expense declaration form with attachments and assets and debt form with attachments. So if that has been served to the other side, and you have the type of retirement that doesn't have to be joined to the proceeding, that would be sufficient to get single status only. However, to keep in mind that single status only doesn't give a final divorce. Bifurcation, single status only, it's only bifurcates, and the word bifurcate I would use as a separation from all other issues that are not resolved. So they will be reserved to be resolved to later timeline, but at first you will be able to be single. So I hope it helps. If you have any questions, reach out. My phone number will be listed below, and my website as well. Anyway, have a wonderful day. If you like the channel, please subscribe, If you liked it, click like. Bye!